Thank you, Adam and Mila, for the opportunity to present. I'm going to set up the research very quickly, and Matthias is going to present the findings. So this project draws on our interest in understanding how global normative changes impact local minority politics and rights provisions. And this is a project for which we've spent a lot of time collecting data, and we're pleased to finally have some figures and tables to present. And I just want to quickly say a couple of things in light of our earlier discussion. One about empirical research on constitutional law. This is a quantitative project looking at all the countries in the world. But we do have a qualitative historical case study component to our project, as some of you know, because some of you are involved in that project, in which we asked experts of constitutional history of each case to present and write about a paired comparison of the evolution of constitutional multiculturalism in those cases. So this is really a mixed method research, and qualitative informs the quantitative, and the quantitative informs the qualitative, going both ways. The second point is we realize that this conference is really about the impact of constitutions, and this paper is not quite there yet, but we plan to do more analysis using this data set, looking at the impact of all these minority rights provisions in national constitutions and how they actually may or may not impact actual minority rights practices. And it's particularly interesting in light of Adam and Mila's book, focusing on or highlighting the impact of organizations. And minority groups have this built-in organizational and group component to it. And I particularly enjoyed the book's discussion about religious minorities in Russia. So we can probably have some discussion about that too. And this is really an early stage project, so we very much welcome and appreciate your feedback. So the research question that motivates this particular paper is how have constitutional rights provisions regarding ethnicity, language, and religion changed over time? And we use constitution as a lens through which to get at the changing relationships between majority and minority groups in nation states. And we see that as a really a conservative constitutions as a conservative measure for changes over time, with life expectancy of 19 years, constitutions are a relatively slow moving target. So we would have more confidence that the conceptualization of majority minority relationships in that country has changed, if not the practice. Conceptualization at least has changed if constitutional provisions have changed. And this paper is motivated by political comparative sociology, theoretical thinking about how local politics change depending on the shifting tide in global society. So in other words, we expect that constitutional minority rights provisions to change over time with the shifting tide of sort of globally legitimated model of majority-minority relations. And in doing our analysis, we use three ideal typical models of majority-minority relationships to orient our thinking and coding. And those three models are, first, the cultural homogeneity model or ethnic nationalism, where the congruence of political and cultural units is presumed. Here, the expectation is that groups that look and act differently would be either assimilated or excluded from the nation state. The second model is individual minority rights model, where individuals ought to be treated equally, that the right of individuals to be treated equally and to not face discrimination based on the ethnic, linguistic, or religious background is protected. In that model, that's the second model, that's the individual minority rights model. And the third model is global group minority rights model, which goes beyond individual minority rights model to grant equal recognition to groups, minority groups, as collective entities, and oblige the states to proactively protect and promote minorities' ethnic, linguistic, and religious identities. So using these three ideal type models as the heuristic device, we code constitutional text to see how those how rights provisions along those dimensions have changed over time. And our expectation in terms of temporal over time, the evolution of constitutional minority rights is as follows. First, the early nation state was really dominated by the cultural homogeneity model. The nation state was expected to have the same cultural and political groups. And this was fully institutionalized in international legal principles as well, in Woodrow Wilson's statements, League of Nations, and even up to the UN Charter. Things changed in the mid 20th century, and the individual minority rights model gained greater prominence. And again, this was also institutionalized in the international community in the forms of Universal Declaration of Human Rights and the two international covenants and other human rights treaties. So that was a step forward in terms of protecting minority rights. But then third, more recently in the last few decades, after the Cold War ended, a lot of advocates of minority rights realized that the universal human rights model, this individual rights model, was not enough to protect minorities, because those groups tend to face sort of unique historical injustices that need more remedies. And based on that recognition, group rights model emerged strong, codified in the 1992 document, and all those documents are listed in the PowerPoint. So we expect, that this rise of more of a group rights kind of model after the end of the Cold War. And we want to test these propositions, drawing on existing empirical studies, cross-national coding work done by some of the participants here. And now I'm going to turn it over to Matthias to present the results.
Yeah, building on the CCP and other recent large N data collections, we have embarked on a large N study of written constitutions in the time period 1789 to 2015. We largely use the CCP source collection with some independent research on constitutional texts. We cover new constitutions and the latest amendments, and arrive at a universe of constitutional documents of close to 1,000 texts. Our detailed coding scheme that we have developed to capture different provisions on ethnicity, language, and religion highlight generic references to nationhood, as well as more specific provisions and general statements about the nation's collective memory and imagined future. The coding scheme has been used by 2 coders, and in the paper we cite evidence on intercoder reliability. With this data set, we try to capture the 3 ideotypical models that Kio mentioned earlier by creating 3 additive indexes, for which you see the kernel density plots on the right-hand side of the slide. The cultural homogeneity model includes provisions concerning ethnic privileges, state, church, official language, etc., whereas the individual minority rights index taps into non-discrimination provisions, individual religious freedom, the right to private use of minority languages, and a host of other specific individual rights. The group minority rights index finally captures those aspects in constitutions that grant independent ontological status to groups, be they linguistic groups, religious groups, or indigenous groups, that I've cited some examples here, and you find more of that in the appendix of the paper. With this data set, we embark in this very specific paper on descriptive analysis, both in terms of global trends of the 3 additive indexes, as well as in terms of cluster analysis, based on the rescaled index to detect subgroups of constitutions within the entire universe of constitutional texts in our data set. So to start with the global trends, going very quickly here, we see that our main propositions are largely confirmed. We see a slight increase of cultural homogeneity over the long 19th century. We do also see a recent uptake in provisions on cultural homogeneity that capture some of what other colleagues like Wen Hirschel have called the rise of constitutional theocracy. But more pronouncedly, we see an increase of individual minority rights provisions after the UDHR in 1948 and an increase of group minority rights provisions after the UN Declaration in 1992. Now, how do single constitutional texts combine these three types of provisions, knowing that many constitutions add layers of different rights provisions on top of each other? The cluster analysis provides some insights into that question. What you see here are the results of the cluster analysis with the two main dimensions on the X and the Y axis, and the cluster centroids given the average numbers for cultural homogeneity, individual rights, and group rights, respectively. We find a culture-blind cluster, which is low on all of these indexes and includes countries such as the US with its 1789 constitution. The nationalist cluster is very high on cultural homogeneity. It is prominent in the 19th century, but also in more recent constitutions like the Moroccan example, which we take from the qualitative historical research of our edited volume, in which in 1972, the Arabic language and Islam were institutionalized as official, and despite recent trends to incorporating minority rights, the cluster membership remains squarely within the nationalist pattern. The civic cluster is characterized by high individual rights, whereas the multicultural cluster finally is strong both on individual minority rights and more collective minority rights. In addition to some of the interwar constitutions like Czechoslovakia 20 or Poland in 1921, it includes Canada with its Charter for Rights and Freedoms and a number of Latin American countries and countries in South Africa. The global trends are supported by this cluster membership analysis. If we look at cluster membership proportions over time, again, we see very clearly the increasing prominence of the multicultural cluster as compared to other clusters in the more recent time period. And in the paper, we also elaborate a little bit on the geographical distribution, which I just skip here in the interest of saving time for our joint discussions. And by way of conclusion, I want to highlight that our paper contributes to the comparative constitutionalism literature by establishing a new data set on majority-minority relations over the long durée perspective. It also provides some initial evidence for changing models of majority-minority relations. Clearly, there are limitations with its focus on large C constitutions and the purely descriptive analysis of highly aggregate indexes. And this is indeed the starting point for the research perspective that we are currently working on, and that pertain to three lines of research. First, more fine-grained analysis of the sub-indexes, that is, how do these different models play out in the distinctive dimensions of difference like ethnicity, language, religion, indigeneity. Second, what are the global and domestic factors that explain the adoption or non-adoption of one of these models, ranging from demographic ethnic fractionalization over constitution writing processes to different degrees of world polity involvement. And finally, what is the impact of these models upon the actual situation of minorities as measured in existing data sets, such as the minorities at risk data set of GER or WIMMER's ethnic power relations data set. We very much look forward to the discussion and to any questions and comments that you may have. Thank you.
Wonderful, thank you so much. So let me see if there's any comments so far. I have one or two or three myself, but Katarina, you go first. You're muted, Katarina.
Sandy also raised his hand, but I'll go ahead and thank you so much for presenting the data with such clarity. I had a comment about the periodization and a question about what happens immediately after World War I, whether there's a rise in that period of minority treaties and whether some of the provisions that you might otherwise in other periods expect to find in constitutions, you instead find in documents that kind of are deposited with the league or in a different form, and whether that's a separate paper, part of the DV here. I see Matthias nodding, so I'm looking forward to hearing more about that.
Great. So we're collecting questions first and then give you a chance to respond at the end, if that's okay. Sandy?
Yeah, two very quick comments, especially since Zach is back. I would be curious if any of the multicultural countries included clauses about secession, and if they did, if that had any consequence on actual behavior. Secondly, and this is actually related to that, how many of your sample set involved constitutional change or constitutional reform as against brand new constitutions by, in fact, secessionist countries from Yugoslavia or the Soviet Union or Slovakia, et cetera, et cetera?
Great. Adam?
Hey, so first off, it's great to see the new data set, and it's impressive the amount of new data that you have on this question. My question is, I was trying to think through how to think about the fact that the indexes have different numbers of rights. And so the first two indexes, I think it was 17, 18, and 50 or something like that. And if the score is just, I couldn't tell, I was just trying to frantically reread to figure out this question, but whether or not that influences the fact that you see some of the upticks over time, and that if there's sort of like the ability to have a higher score on the third index and there's more rights that are happening over time, that it's sort of just mechanical and not necessarily a change in perspectives about constitutions. That's it. For what it's worth, like, your hypothesis seems definitely right to me. So, I'd be surprised if this number of rights could drive the result. But just, I'm not sure how to think about whether or not it should be standardized or something like that.
Yeah, and I can maybe, one of my questions also related to the indexes. So as I was reading through them, I had some quibbles, right? Like, oh, individual rights to a different culture. Are they really individual rights, or are they more like group minority rights, or can we easily distinguish? Which led me to a bigger question, I guess, is it seems a little bit, I don't know what the word I want to use it, but maybe overly complicated, or maybe not, right? But you first have theoretically constructed scales, and then you do cluster analysis. And in some ways, what I wanted to see, maybe in addition to the theoretically constructed scale, is some sort of ideal point estimation on your 97 or whatever variables, and see, which variables actually do go together here, right? Would you see the same sort of theoretically constructed scale if you only let the data speak, as opposed to putting it yourself together as a researcher? And I'm always very sympathetic to theoretically constructed scales, but I can see a case for doing both. And then you can look at how these, what the underlying dimensions are for whatever form of ideal point estimation you use, and how countries cluster together that way. It feels a little bit indirect in some ways, I guess. Sorry, I had another, okay, so I have Stefan and then Alexander, but Stefan.
Yeah, extremely impressive, the data set, extremely interesting. Just one question, I'm interested in the issue whether, depending on which cluster a country belongs to, you could be asking to what degree these rights are implemented de facto. Does it make a difference whether I have a sort of a very culturally homogeneous group, and then all rights, whatever they are being implemented? Whereas if you move on, it gets more difficult to implement these rights on the ground. So I'm interested if you're planning to look at the de facto implementation of these rights.
Okay, great. Alexander?
Yeah, sorry if I get cut off. My internet's been a little dodgy this evening. Anyway, I'm super excited about these data. And one of the questions that I had is sort of the sequencing of adoption in terms of increasing diversity through migration. So a country like Canada has always had fairly high levels of immigration, for example, but it was sort of exclusive up to a certain point in history, and then it became more inclusive. And so I wonder if that's part of the story of adoption of minority rights. And then alongside that, of course, is the recognition of indigenous rights. There's no clear reason why it shouldn't have happened before. And so I wonder if your data will help us sort that out. Thanks.
Great. Neda?
How did you know I have a question? I didn't even.
You were clapping on the participant.
Oh, okay. That's.
So I read your mind, obviously.
That's a report, yeah. No, I'm just generally very interested about this project, and I guess my question is more of an invitation to ask you, what else are you planning to do with this data set? And are you planning to, for example, try to cross it against some outcomes, or try to see like minority majority population surveys and understand whether the enactment of constitutional provisions, for example, on the multiculturalism end, maybe has improved or influenced. I mean, this causal inference is a big word, but maybe look for correlations in how maybe constitutional amendments are related or potentially influencing public opinion. I would think this is important to look at majority-minority relations. And also as a side note, I mean, because I've been doing work on this question recently in the context of Israel's nation law, the new amendment that's very much on the nationalist side of the constitutional amendments, I can send you lots of, citations that maybe could be helpful for you.
Okay, great. Did I miss anyone? I also just wanted to echo that obviously it's great to have this much more granular data on this topic, and I think it's a great effort. I should maybe note, like, one of the things you guys try to do, which is something Mark Tushnet criticized Adam and me for not doing, is you actually do take into account, you do code half rights, right? Like whenever there are limitation clauses that seem to limit the scope of the right substantially. At the same time, I do also have a ton of questions about this, like how do you determine whether, I mean, sometimes the Constitution says, except as provided by law, is that good or is that bad? Like potentially it sounds like everything can be limited, but maybe not, because it's a guarantee that there, I mean, there's a really big debate about whether or how to code limitation clauses. And David Law and I wrote about this a little bit. And we basically, I mean, you may disagree with my assessment, but my assessment was we couldn't really figure this out without going much more deeper in the jurisprudence of these countries. So I guess one thing I would want to see is, what if the half rights are whole rights or not rights at all, right? Like, does much depend on this, especially as you go forward, taking up these questions on impact and such. But okay, with that, I think, did I miss anybody for questions? Nobody's speaking up, so I guess that gives you some 5-6 minutes to respond.
So I'll just quickly address what Mila just said. I mean, in the end, it's a judgment call, right? We have multiple coders, and then if there's disagreement, we tend to look at the disagreement. But what we aspire to do, what we do is to be transparent. So all the texts, constitution texts that are basis for our coding will be available on the web. So if people disagree, then they can look at that text for each constitution, and we'll definitely take into account if there's strong disagreement. If we may have made mistakes, but that's the extent to which we can address that issue. And quickly also on the future plans, I'm glad that there's a lot of interest in this data set and how we might use it. So this is really a first stab at the empirical analysis, and it's very descriptive at the moment. We first would like to look at what drives these changes over time. Is it really the global normative change really is the main driving force of these changes? If so, which legal text, international law, might be driving that? And if it's more of a domestic, similar domestic factors can be found in countries that are leading these changes, then what are those factors, and how those similar constitution provisions diffuse across within the region maybe and across regions, in the same countries that had the same colonial power as colonizer. So there are all kinds of different dynamics in play that we want to look at in a systematic quantitative analysis. And then we want to take a look at how those provisions do or do not have an impact on the actual practices of minority rights. And there are a larger number of cross-national quantitative data on minority rights practices today than around 20 years ago. So we'll draw on those data to look at the impact of those provisions. Well, I should probably turn it over to Matthias about some of the questions. And I think on Adam's question, I think we rescale all the cluster analysis, use the rescale data. Maybe one of the descriptive tables did not. I'm not sure. I have to look at that again. I'm not sure. Secession clauses, that's a very interesting question. We have to look back at it. We don't remember a lot of those clauses. So my hunch is that there weren't too many of them, but we do think about, in a different project, we do talk about different kinds of multiculturalism. One is really committed, like sincerely committed to promoting protecting minority rights, what we call committed multiculturalism. And then there are different types, and one of which is a preemptive multiculturalism. In a country where a minority group is always threatening, is always a threat to become an independent nation state, the government might actually give a lot of rights, group rights to this group to prevent secession. So that dynamic is certainly in play, and we look at that in a qualitative way. We don't have a clear answer in a cross-national quantitative way at this point. I think I said too much, so Matthias? And Charles, you should chime in with the analysis about sub-indexes.
Very briefly on the interwar question, I mean, that's clearly a period in which the first attempt to institutionalize minority rights has emerged under the League of Nations, both in the minority rights regime in Eastern Europe, as well as in the mandate system. And it is reflected in some of the constitutions that have been adopted under the influence of these legal provisions. And we see this clearly in our data. In terms of your question of how whether the actual rights are more enshrined in international law than in constitutional law, that is something that we cannot really address with this particular data set. But we are very much interested in matching our data with data about the increasing density of human rights treaties, and this clearly goes to the League of Nations period as well. I should also add that in a side project that I'm involved in with colleagues in St. Petersburg, we are looking at the nationalities discourse in the Soviet states, which is very prominent for some of the post-Soviet states. And this also is visible in much of the subnational constitutions in the 20s and 30s. So this is clearly a period in which the first attempt to institutionalize minority rights without necessarily granting the kind of civic equality that the post-World War II human rights regime has established entailed as well. There was one more question on on immigration. This is clearly one of the aspects that we try to disentangle with our more causal analysis, to what extent demographic changes, including diversification, waves of migration, have an impact in the long term on constitutional changes. And Alex, if I understood correctly, the indigenous rights are clearly part of the rise of minority rights prominence in the 1990s in the global legal arena as well. There was one question on implementation. This is an area that we don't really specifically look into in terms of legal mechanisms of implementation of these constitutional provisions, because we are really interested in the self-portrayals of nationhood that constitutions entail. So that is something that we will look into when, as Kiyo said, we will analyze the impact of constitutional provisions with other data sets, like, as I mentioned, the ethnic power relations data of women, etc. Perhaps one last reference to the theoretical index versus factor analysis. Maybe that's something that Charles can also chime into briefly.
Yeah, so on that, one thing we could do is take the indices as they are and run some sort of confirmatory factor analysis. We didn't do anything exploratory. At the end of the day, you still have to view those results through a theoretical lens. You have to put together some theory that combines, you know, the factor analysis output into kind of theoretical constructs. And we just had stronger theoretical beliefs and thought it would be better to make an index the way that we did to begin with. So I guess the decision between whether you do what we did in exploratory factor analysis is really how much you can kind of lean on theory at the start. So different people could do different things since we're providing the raw data anyway. And then the question about scaling. So in the Kia was right, we provide in one of the figures the raw data just for transparency and to make sure that people actually understand what the actual distributions look like when these indices are combined or compiled. But for any analytical work, we scale everything. So, and I'm sorry if that was a choppy reply, but again, 5:18 in the morning here. So.
No further questions. Okay, I guess let's, or there may be further questions, but not right now, Charles. So I think, and with that, actually the next paper is ours, but Adam is presenting.
Great, can everyone see, Mila, can you see the slides on my screen? Cool, all right. So this is a new paper that Mila and I finished, I don't know, maybe Monday or something like that. So it's brand new and this is the first we're showing it. And it's a topic that we did not cover in our book or any prior papers or research we've done, which is whether or not constitutional provisions that guarantee gender equality actually result in improvements in de facto gender equality. So do they have an impact? Now, it's in part inspired by the story of Japan, which in the wake of World War II, Japan's constitution was drafted by a team of Americans under the direction of General Douglas MacArthur in just 8 days. And there was one woman on the team, Betty Sirota, who had both spoke Japanese and English and was a Japanese American, and hence her role on the team. And is given credit for putting a strong gender equality provision into the Japanese constitution that said that all laws shall recognize the essential equality of the sexes, which quite strong clause, and one that she had hoped that would help to improve the status of women within Japan and to eliminate some formal gender inequalities within Japanese society. Now, in the time that when the Japanese constitution was written and enacted in 47, there were relatively, these gender equality provisions were present in some constitutions. So for instance, on this graph on the left-hand side here, this is the percent of countries in the world that have a gender equality provision in their constitution over time. You see it's roughly 20%, something like that at the end of World War II. And by 2005, it's at something like 82%. So a big increase in the percent of the world's constitutions that included these gender equality provisions. Now, at the same time, gender equality has, in a de facto sense, improved around the world. So the dependent variable we use throughout this project is a measure called the Historical Gender Equality Index. And the way that it's constructed is that it's 6 variables that are taken from the World Development Indicators, which are measured for both men and women. And then the measure is the ratio between those two, which is life expectancy, marriage age, birth ratios, workforce participation, education rates. And so essentially a score of 50 would mean that women do half as well as men on these measures in a given country, and a score of 100 would mean that they do equally well as each other. And you've seen there's an increase over time going from roughly an average score of 60 to an average score of 70 during the post-war period. So women's rights has improved, although of course there's still ground to be made up, and it's not reached full equality in things like workforce participation around the world, but there is noticeable improvements. But the question that we had is whether or not these trends are actually causally related and not just correlations that these two things both took place in the post-war era. Now, as was discussed this morning, the theory in our book is that constitutional rights that are organizational in character are likely to improve de facto rights protections, but purely individual rights are not. Now, gender equality provisions are kind of unique and fall, as we were discussing earlier in some of the discussion with Zach and others, fall sort of in the middle of a spectrum, perhaps, in that they both recognize a specific group. However, unlike the right to form a union or a political party, you don't have to exercise the right to gender equality within a group. For instance, to be a woman that is able to take advantage of this right, you don't have to be in a women's rights group in the same way that you might have to be in a union or a political party. Beyond that, it's a quite general right that it's not clear what it specifically protects or what it accomplishes. And there's also within countries often quite a bit of disagreement between between women or different groups of women for what being gender equality means or what feminism means, et cetera. For instance, we're seeing this right now in the United States where Ruth Bader Ginsburg was a pioneer of women's rights. Amy Coney Barrett's being hailed as an example of being a pioneer for women. They seem to think the opposite thing on every single question. So there can be big differences even within people that are representing women's rights or women's equality. So what we did in this paper then to test this is we used 3 different research methods in the same paper to get at this. So the first method is just cross-country regressions to see whether or not countries that add these rights to their constitutions do better after. And we, for the most part, we use both panel regressions and event studies with 2 different ways of doing this. But I'll show you the event study results. So this is countries with and without, the red line is countries that added the right to gender equality into their constitution before and after adding that, 5 years before and 5 years after. And the dependent variable is that historical gender equality index that I mentioned. Now you see that countries are improving sort of gradually over time when they add this right. But when we construct a set of control countries, which are countries that did not change their right during the exact same period, the pattern's identical, essentially. And so we can expand this time horizon for longer periods. Whatever way we chop it, it seems that the trends for countries that do and don't have these rights are really moving the same way. And the result is our regressions produce essentially null results. And now, not only are the results null results in the sense that they're not statistically significant, the effect sizes are just really small on the coefficients. So these are statistically insignificant coefficients, but even the 90% confidence interval, which this is what's graphing here of our various regression specifications, never even gets to 0.2 standard deviations. So we can rule out even a small effect, which is what 0.2 standard deviations is sometimes considered based on our confidence intervals. So we have pretty precise null results from both panel regressions and stacked effect regressions, which based on that raw data that I just showed you should be unsurprising. There's really nothing in the raw data. All right, that's method 1. Method 2 is a natural experiment based on Japan's experience itself. Now, Japan, for the reasons I described before, presents kind of a nice natural experiment because you have an exogenously imposed or adopted or whatever we want to call it, constitutional right that's based on these sort of random fluctuations in history, and not endogenously driven women's groups within the country of Japan. So to show you this natural experiment, here's again, the y-axis is the historical gender equality index. The x-axis is time. Here's 1947 when Japan adopts its constitution. Here's Japan's score over time on the historical gender equality index. Here's all countries in the world. Now, since we're averaging a lot of countries, the scores are smoother. And here's all countries without the right to gender equality. In effect, they start and end in nearly the same exact place. They start in roughly a score of 61 and they end at a score of roughly 69. So Japan doesn't seem to make more progress than the world in general or other countries without this right. So what you might think is having this right sort of imposed on Japan didn't help Japan accelerate and have a faster trend than countries on average. We also show this with a series of regressions. What this graph figure shows you here is we take, for each year on the x-axis, we regress all observations, country year observations before that year that don't have the constitutional right, and essentially see if Japan's doing better than them in their trend. And in fact, we often get statistically significant negative results. Given how rich, democratic, et cetera, you'd think that Japan is actually should be doing better than it is on gender equality. So it's not a great cause for hope based on the regressions either. All right, third method that we use is a survey experiment. And this is a little bit like Kevin and Charles discussed this morning, and some other survey experiments that have been used in the past. And Charles actually helped us, since his position in Tokyo, to administer this experiment last March, shortly before the coronavirus pandemic, which is we conducted a survey of 2,400 people that were representative across Japan. Within the survey, we asked about 6 questions where the Japan code has explicit differences based on gender in their civil code. For instance, the marriage age shall be 16 for men and 18 years of age, 16 for women and 18 years of age for men. Let's see, what are the other things? Remarriage, there's a different numbers of days that men and women have to wait to get remarried. Rules about changing your surname, and who can be the emperor of Japan. So these are aspects of the civil code where there's explicit divisions based on gender within the civil code. And the experimental manipulation is some people were just showed the text of the Constitution before these questions. And like I said, there's a pretty clear right to gender equality within that Constitution. Now, this is slightly different than some of the research designs we talked about this morning, where we with Kevin and Charles, and prior research Mila and I had done in the book, where in the past we'd said, some experts say this policy is unconstitutional, or something like that. And instead here, we just showed people the Constitution before asking them about these differences. I'll just briefly show you the results. The results, these are along you see the 4 plots of those 4 different policies, those 4 different policy questions. The y-axis is support for the reform, and then the different things on the x-axis are different experimental manipulations. What's important for our purposes is the different experimental manipulations did not matter at all. And so being shown the text of the Constitution didn't make people more or less supportive of these reforms, perhaps for some of the reasons that Charles and Kevin got at in their paper. We look at these results conditionally, based on constitutional knowledge of women's rights internationally, gender attitudes, based on questions from the World Value Survey. And again, we don't find any conditional effects either. These are just like pretty straight null results. So across 3 different methods, we not only find no effect of gender equality, but it's a pretty precise 0 in all of these methods. That the constitutional right to gender equality doesn't seem to change attitudes or actual improvements in de facto gender equality. Now, one thing that I'll end on is that we focused on gender equality provisions generally, but it's just the last paper showed that there's a huge range of ways that constitutions treat minority rights, and not just general gender equality provisions. So one thing that we've got coded up a little bit is rights protecting motherhood. And so we coded countries if they had one of 3 kinds of rights in their constitutions, which is the right to maternity leave, the rights of pregnant women, or the rights of mothers, one of those 3 concepts mentioned in the Constitution. And we reran some of our same regressions. So this is the results I showed you before, regressions showing results from gender equality provisions. Here's the same specifications, and the red lines are now where the independent variable is motherhood rights instead of gender equality generally. And what you see is the results are, the coefficients are now larger, and for some of the specifications, statistically significant. Now, we don't really draw any firm conclusions from this other than to say, maybe in future research, we should look into this more. Ideally, we need a better dependent variable that was more perhaps geared to motherhood instead of just gender equality generally, and to look into this more. But it's possible that the right that is more specific and more concrete might do a little bit more than just the gender equality provision generally. All right, that's everything, and I'll stop there.
Great. Now I am going to really have to constrain myself as a moderator and follow the same rules as with everybody else. So I have Alex and Mark and Katerina on the queue, and we're not going to answer until there is like 3 minutes left at the end.
So Adam, could you go back? I know you don't have the slide, but I seem to remember that on the event study slide, you showed a very oh, okay. You're going there?
Yeah.
Okay. Now, if you, yeah, it seemed to me, it's very small, but it seemed to me that there was there's maybe a bigger slope for a bigger slope in countries where they adopted the right just before they adopt the right.
Mm.
That would be just something interesting to look at. I mean, it seems to be very small, but just intuitively, you could imagine that maybe if there is a major push for women's rights, then you also put it into the Constitution, and it's like sticking it into the eyes of those who were against it, that now we even put it in the Constitution, and it is more the completion of a process and not so much something that triggers the process.
Great. Mark Graber. Adam, your screen can be shared seen by everybody still.
It's important because I actually did some empirical research. This is the impact of the 19th Amendment. And I'm reasonably confident it's robust. Around here is 1900, women's vote goes up slightly. The 19th Amendment, it goes up dramatically, and then probably slightness. And I think this suggests a feature of this first. There's a general agreement the 19th Amendment changes the law. The part is specific. When you have a constitutional amendment that the national government is committed to, as the national government was in the 19th Amendment, and everybody agrees it changes the law, it works. Part of the issue, I suspect, on equality goes back to something Mark Tushett said earlier, and I may say a little bit later, and that is everything Japan was doing could be defended in terms of sex equality. So in fact, separate spheres is a version of sex equality. It's not one any of us agree with anymore. But I do think that one of the conclusions at the end is when you are specific and have national support, rights have real effect. When you use an essentially contested concept, all it does is force people to change the language with which they defend inherited inequalities. But if this strikes me as a given today, this may be publishable. I'm hoping.
University of Chicago Law Review Online will publish it for sure.
Hey,
no,
one more.
I want to respond, but I cannot. I have a question by Katerina.
So thank you very much for this. I wanted to recommend that you take out the Japan part for a couple of reasons. One is just among kind of feminist and other circles, like the one study that is the puzzling one as to how can a rich country like do so poorly on this metric as Japan. So I think people are just going to react negatively because of the identity of the country. I have a methods question, which is, I think you have a natural experiment because you're saying, look, Japan just got a constitution imposed on it, and therefore kind of this is really nice and external. But I do wonder whether that's not the case, because if someone imposes a constitution on you and you already had the right because of kind of cultural reasons, because you were a progressive society, this treatment, like it's only a change if it's imposed plus you didn't have it before. So it's not really a natural experiment. That's my methods question, and I think I might be confusing. So imagine that like the US imposed constitutions on 100 countries and half of them already had gender equality in them, and you saw kind of how is that not something that compromises the idea of a natural experiment.
Qualification on that are you saying that Japan already had gender equality pre?
No, I'm saying it didn't, but that made it different from some other country that lost World War II that already did it. I mean, I'm making up an imaginary other Japan that already had it. So kind of we imposed all the constitution, but that particular right had already been developed internally. So that's my methods problem. My pragmatic point is Japan is well known for this feature, so it would be just unusual to focus on it. It would be kind of the easiest, instead of picking like the most difficult case study, look at this country where we think we've made like look at Sweden, we think we've made tremendous progress and it has nothing to do with constitutional rights. It's all about the labor unions. It would be like, look at this one country that everyone knows performs poorly. My question is about your kind of the last, actually, I have another question on the second part, but I'll return to it.
Okay. So you don't want to ask the question now? I mean, I guess
I can just out of the two.
Yeah.
Part two to my question. I'm happy
as a moderator and first give the floor to but I've been myself also asking two questions. But I guess Charles has a question, and then I'll see if there's time for second round questions.
Although I acknowledge the issues of using Japan as the case here, I'm happy to see any work focusing on Japan. The one question I have though is similar. How do we interpret treatment here? Right? This is a really odd treatment. And it's not necessarily that it's not an actual experiment, but just like this is a multi-pronged treatment. It's multi-barreled in every sense, right? And like what is it that like how is it exactly that we should think about it? Because there's so many other things going on. And I think that like if we're going to get in the counseling of what section of the paper you would drop, it's that part that I actually find to be the least empirically satisfying. So just my 2 cents.
Okay, great. Katerina, why don't you ask your next question, and then Adam and I have 5 minutes to respond, I guess, if anybody, unless any.
Zach, Keo, Alex all have their hands up.
Oh, okay, I'm doing a horrible job. Okay, Zach. Zach, we cannot hear you.
I'm sorry about that. Let me see if I can share my screen. I wanted to show something. I have an undergraduate lecture. I want to hear more from Katerina about her objections to Japan, because I find it interesting. I've always found Beata Sirota-Gordon's role interesting as a 22-year-old who somehow has this kind of influence. And I think might be interesting. I've gathered a little bit of data on this. Article 24 about equal marriage is a really interesting one. And then I have some data, I feel like a sociologist almost, some data here on love marriages, which really went down right after the Constitution, arranged marriages went down dramatically as against love marriages, which is kind of a very interesting objective indicator of some changes. And then the other interesting indicator from a demographic perspective is the fertility rate, which obviously is highly related to independence of women. And the choice of whom to marry and the fertility rate seem like real changes for women, and might be something that you could look at maybe in the same way you do your synthetic controls with other like situated countries, and see if fertility rate and marriage choice changes dramatically with those synthetically controlled countries. Because it seems like if I just look at Japan here, it's really quite dramatic. And I just wonder if that's a post-war thing, a constitutional thing, or just let's say a life cycle thing in terms of, or generational thing in terms of the 1950s. So I'll leave it there.
Great, thanks so much. That's great. Keo.
Great. What Zach showed in the constitutional text is now being dissected by proponents of same-sex marriage, right? What does both sexes mean? Does it mean two different sexes or not? Anyway, so that's interesting. I have a lot to say about Japan. I'll try to limit myself. So many people already commented on this, but I think a more often used example of Japan's intransigence in terms of gender equality rights is a 1985 law on equal employment. I don't know if there's similar analysis to be done or maybe already has been done, but that might be a more sort of, following on Charles' point, more appropriate kind of a natural experiment than the Constitution in terms of gender rights. I think there's something to what Alexander said about adjustment right before the legal change. And this is in the more international human rights law domain, but a country like Japan really does a lot before ratifying those treaties, making all kinds of adjustments to comply with the international law. And it's not the same thing with Constitution, but something similar might be happening in civil society to adjust to the coming law. Not in the case of Japanese Constitution of 1946, but that uptick right before the legal change sounded interesting.
Great. So Alex, you had a question?
Yeah, just out of interest, is there studies on constitutions that have been forced on countries and how they are different from constitutions that were kind of developed by the country and their effect?
Mm-hmm. The answer is to some extent, but I guess I don't get to answer, but thank you for the comment. Katerina, why don't you ask your last question, and then Adam and I just get only 1 minute each to respond. What about that, Adam? Fine.
So my last question is about your DVs, like how we think of women's rights, and a little bit unusual to me when I saw the list on your survey where you looked at kind of age of consent and surnames and divorce rates, that it would be claims brought by like first generation feminists, so claims that are not what women's rights organizations have been kind of centrally advocating about. And I like that you shifted more towards kind of maternity rights. And I'm wondering whether the Millennium Development Goals and some of those goals for gender equality, like something more banal, like closing the gap in education, which I think in Japan is actually quite close. It's the workplace participation gap that is huge, might persuade someone on the valid. I'm not exactly sure what's in the index, but I just saw those questions and was a little bit surprised that you were focused on them.
Okay, great. I think Adam and I get a minute each. What about that? So let me respond, I guess, Katerina and Mark's point and point others have raised. So Mark's point is like if a provision is much more specific, we see a much more effect, much more clearly an effect, and if it's general, it's much harder. And I think that's part of our point, right? It's really hard to agree on what gender equality really means among feminists, among women. So there's that, and I guess that takes me to the maternity leave provision. So my intuition was like, yes, they do potentially matter more, both in terms of our theory, right? Like that we set forth in our book, mothers may have a clearer identity of that they can organize around. This is a much more specific provision. It also turns out, although it's kind of counterintuitive, because in some ways it's like, it also could be a paternalistic provision, right? Where we're protecting mothers as opposed to women as equals. But there is very interesting jurisprudence in Germany, for example. The German Constitutional Court has used these provisions to require mandatory maternity leave. And people like Julie Silk are arguing that this is really what we ultimately need to promote women gender equality in industrialized countries where we're formally equal, but really the only way to level the playing ground is to recognize the disadvantages that women face as mothers. So I do think in that sense, I'm kind of excited about that part, although it's harder to show causally, which brings us back to some of the questions. Like how much methods do you want to use and how much intuition do you want to use and so forth. Okay, Adam.
Yeah, a theme here with my colleagues at Chicago is that every single law paper is just rules versus standards. And so the game at our workshops is to show that. I think that Mark's graph got at that perfectly, which is within constitutions, what seems to really be clearly respected is the rules and the standards don't do much. And for instance, Mila and I think others have the example of things like the number of terms the president can serve or the age that you have to be president. I don't think there's a lot of explicit violating of those provisions in the same way the 19th Amendment is respected. But the second you move to like a bit broad standard like gender equality or religious or like freedom of speech or whatever, it doesn't seem to move the needle very much. And so I don't know how much of it is about concrete changes or recognizing that it's legal or not, whatever. But the rules seem to matter a lot. And I think that Mark's soon to be published graph really does help to illustrate that. All right, I think we'll stop.
In the Chicago Law Review online.
All right, I think we've got now a roughly 15-minute break before we come in for another panel with 4 more people.